The ruling wasn't about a fine, it was about the source of the money itself. In 2024, Judge Amit Mehta confirmed it. Google used its monopoly power to maintain supra-competitive ad prices, the financial engine of its empire. But his 2025 remedy targeted something far more valuable than cash. He ordered Google to give its rivals access to the very data that makes those ads so effective. This was the culmination of a legal war started by the DOJ in 2020, which alleged that Google's billion-dollar deals to be the default search engine were illegal. Now, the remedy strikes at the heart of Google's business model, a self-reinforcing flywheel where more data creates better results, attracting more users and advertisers, and justifying the very prices the court condemned. It's called a virtuous cycle. The government calls it a monopoly. The entire battle hinges on one asset, the search index. This is not a list of websites. It is a proprietary, living map of the digital world. Built by crawling the web, but refined by something far more valuable, a torrent of user interaction signals. Every query, every click, every millisecond of hesitation is data that trains the ranking algorithms. It tells the machine what is relevant, what is authoritative, what is asterisk useful time. The index is less a library and more a learning organism. And that organism generates staggering economic power, a gravitational force. The ecosystem built around it is responsible for hundreds of billions in annual search revenue. It's an engine that converts human curiosity into monetizable ads at the exact moment of intent. Google's legal defense is rooted in this. They succeeded on the merits through sustained investment, innovation, and a superior product. Superior engineering built a superior product. But for any rival, this creates a near insurmountable barrier. You cannot build a map this detailed without the journeys of billions of travelers. The scale of data needed to train a competitive algorithm is itself a moat, not of stone, but of learned intelligence, a moat that widens with every search. Which is precisely why the DOJ didn't attack the moat's existence. It attacked the deals that allegedly guaranteed no rival could ever fill it with enough water. $20 billion in 2022 alone. Every single year. That was the price Google paid Apple to remain Safari's default search engine. A sum larger than the GDP of some nations, flowing not for a product, but for placement. These agreements, extending to partners like Mozilla, formed the trust architecture of the digital world. The DOJ argued this wasn't a business deal. It was the primary mechanism for illegally locking down a monopoly. The very map of digital discovery was at stake. Google's defense was clear. This was merit, not muscle. Its legal briefs maintained that partners chose Google for its superior experience and revenue sharing. The contracts held no exclusivity clauses. In their telling, this was the prize for winning the race. This was, they insisted, lawful competition on the merits, a reward for building a better product. The Department of Justice saw a starkly different picture. They called the payments a preemptive strike, not a reward, designed to block rivals from ever accessing the only distribution channels that mattered. From this angle, Google wasn't winning a contest. It was underwriting the contest's cancellation. The presiding judge ultimately called the default extremely valuable real estate, and the government argued Google had allegedly purchased the deed. The trust built on these billions created an ecosystem where Google felt inevitable. The court faced a fundamental question. Were these agreements the legitimate cost of victory in a fair race? Or were they the very thing that ensured the race never truly began? The government's case didn't stop at browsers. It reached deep into the pocket of every Android user. The allegation was that Google had engineered a second fortress. Through agreements with device manufacturers, Google allegedly baked its search engine into the very operating system running on a majority of the world's smartphones. This created a powerful parallel channel of control, walling off a substantial share of the search market before a rival like Bing or DuckDuckGo ever got a chance. The strategy was simple. Wherever you searched, Google would be there first. Judge Amit Mehta's August 2024 ruling gave this theory concrete, damaging teeth. The court found the cumulative effect of these distribution deals wasn't just a theoretical squeeze, It led directly to super competitive search text ad prices. In plain terms, with competition locked out, advertisers were paying an overcharge. This was the smoking gun. The government's trail of internal documents, negotiation emails, and market data had convinced the court of a real economic harm. Google's appeal hit back hard. Their counsel argued the Android agreements alone accounted for a negligible share of queries. They insisted the court's market was drawn too narrowly, unfairly ignoring specialized search competitors. The harm, they contended, was an illusion created by a flawed map. But the map had already been redrawn in court. With the finding of concrete economic injury now on the record, the legal battle mutated. It was no longer a debate about competition theory. It became a referendum on a single, towering question. What remedy could possibly unwind a monopoly loop decades in the making? The answer came in September 2025, and it was devastating. Judge Mehta's order was surgical. A 6-year prohibition on the very exclusive distribution agreements the court had found illegal. But the blade cut deeper than that. The remedy mandated that Google provide syndicated search results and advertising inventory to qualified competitors, prying the gates of a walled garden wide open, challenging a business model built on over $90 billion in annual search revenue. The most interventionist component, however, targeted Google's core intellectual property. The order compelled the company to share its most valuable asset, anonymized user click and query data. This wasn't a fine. This was a forced opening of Google's search index, user interaction data, and ad syndication. The very infrastructure competitors needed to mount a real challenge. For the first time, a court had ordered a dominant firm to hand over the fuel, powering its own technological engine to the very rivals, trying to build a better one. The response was immediate. On May 22, 2026, a consolidated legal team from Munger, Tollison Olson, Williams & Connolly, and Ropes & Gray filed a 100-page appellate brief in the D.C. Circuit. The argument in case number 26-5023 was precise, and it struck at the remedy's foundation. The order was not causally linked to the established harm. It was, they contended, an unprecedented overreach, one that exceeded equitable bounds by amounting to a forced divestiture of its core intellectual property, effectively cloning its most valuable assets. A market, Google's lawyers stressed, that had never been at issue in the original trial. The legal fight had now crystallized into a single, precedent-setting question. Does a behavioral remedy that forcibly opens a monopoly's IP bottleneck represent legitimate antitrust enforcement, or an unconstitutional judicial taking? The D.C. Circuit's answer would define the competitive landscape for the entire AI era. The appeal now before the D.C. Circuit will not just decide Google's fate, it will redraw the legal boundaries of what a dominant firm owes the market that made it dominant. With oral arguments anticipated for late 2026 or early 2027, the case is poised to establish the controlling standard for tailoring an equitable remedy in a platform monopoly case. The central legal question is whether a court can compel a dominant firm to share its core intellectual property, the proprietary data fueling its success, specifically to foster competition in an adjacent innovation market like generative AI, a market that, when this lawsuit was filed in 2020, hardly existed. The outcome charts one of two futures. If the district court's remedies are upheld, it sanctions a new era of interventionist antitrust enforcement, a legal template for regulators globally to mandate data access from market leaders. International bodies in Europe and Asia, already scrutinizing how proprietary training data distorts AI product markets, are watching closely. They have their blueprints ready. If the D.C. Circuit vacates or substantially narrows the order, it draws a sharp line in the opposite direction, reaffirming a high judicial bar against behavioral micromanagement, protecting a firm's core assets from forced sharing. The message: punish the conduct. Don't commandeer the innovation. This legal conflict transcends a single company or product. It forces a fundamental reevaluation of how markets function, when the most valuable raw material is intelligence itself. If a court can ultimately force Google to share the building blocks of its digital intelligence, the index, the data, the signals, does this simply create competitors? Or does it permanently transform the nature of search into something it was never designed to be? A regulated utility, with every dominant platform on Earth waiting to learn its own fate.